My Lord, I don't think it would be appropriate. I don't think the respondent needs to be out of pocket, with all due respect. But I understand that it's a novel point.
15 minutes, my Lord. Firstly, I must just start with a correction. The Kutuane matter, I submitted or stated that that matter dealt with a civil law marriage. It's not correct. This is a pre-constitutional matter. It was heard on the 14th of August 1992. So it deals with a customary law marriage, but it was argued on the basis of the common law foot, Van Leeuwen and those authorities. And it's in that context that the judge made those remarks. There's another matter that I just need to also draw your attention to. It's the matter of MT and MC, MT versus MC and Faith Funeral Home. We will upload the reference on case lines. It's the case number. It's a decision by Adams J, Mr. Justice Adams in the South Gauteng High Court. And in that matter also, he came to the conclusion that where there are multiple competing and practical considerations or multiple competing claims, these cannot be ignored and cannot be governed and resolved strictly on the basis of the principles according to the granting of interdicts. The court is obliged to adopt a practical common sense approach. So what the court here did was exactly what the court did in the Tambo and the matter that I referred to.
Which case would that be?
It is this case of. It's MT and MC versus Faith Funeral Home. My Lord, I don't know if it is in the bundle. It's not in this bundle. It's either referred to by my learned friend or it was referred to in the matters that were quoted. So we will upload a copy of this decision, but it certainly also lends support to a more equitable approach. Or more common sense approach, and especially in this type of matter. Firstly, starting with the submission, which I found rather extraordinary, that the late president was an ordinary Zambian. That is simply preposterous. But that argument it's grounded on the provisions of the Benefits Act. And the applicant, through the mouth of the Attorney General, says the Benefit Act is clear that the benefits are just suspended for so long as you engage in active politics. Upon his death, that impediment or the reason for the suspension falls away and the benefits become payable. One of the benefits is funeral costs. And what the Attorney General says is this is the way the Act should be interpreted, which is in the realm of, obviously, your lordships and my lady can read the Act. The Attorney General confirms that a sensible interpretation is the interpretation that the applicant attaches to it.
Are we getting an assurance that PESAL now in Zambia is running in favor of the widow?
It will, it must. That's what the Act says. She will get a house, I think she gets a car, children get benefits, those will follow. It's in the papers. Then,
the concession, maybe not as to how the actually custody is found.
yeah,
The concession that is made.
based on the papers, my lord, yes. The first point, the question of the wishes of the deceased, what my learned friend did, there's a fancy word to it. If you look at the line and your eye jumps to another point, there's an explanation for that. Your Lordship, or the court referred, my learned friend, to what is stated as far as the wishes of the deceased are concerned, and that is in paragraph 7.6. The family objected that the late president stated his wishes. My learned friend said, no, but that's denied. And then he referred the court to paragraph, the answering affidavit, paragraph 19.1 on 044. But if you look at 044, paragraph 19.1, no, sorry, my learned friend referred to paragraph 24. He said, it is denied that the president would preside over a state funeral. It was proposed that the current president only be allowed to receive fondue. So his answer to was that, were those the wishes of the president? He said, no, look at what he stated in 24.2. But that deals with an entirely different paragraph. That deals with 7.10. We are busy dealing with 7.6. 7.6 sets out the wishes of the family, or the late president, and that is dealt with in 19.1 on 044. And there the respondent says, the proposed conditions of my family are stated herein. From the listed conditions, it is clear that the family would not agree to the current president playing any role in the burial of the late President Lungu. So they don't take issue with the fact that, on their version, those were the wishes of the late president. So the submission that there is no evidence as to his wishes is wrong. It is, as we say in the supplementary founding affidavit, paragraph 7.6. It's not denied. Then the second point that my learned friend forcefully argued, there was no agreement. What he never referred to is what is in paragraph 9.5. 9.5 of the supplementary founding affidavit on page K24. 9.5 reads, the seventh respondent, Mr. Zulu, set out the compromise agreement that was reached. My learned friend didn't deal with that because he can't. On the family's own version there was an agreement. So they can't turn around and argue and make submissions contrary to what is common cause on the papers. Mr. Zulu set out, number one, will be repatriated. I'm not going to go through. So my submission is simply that contention that there was no agreement is untenable. That takes me to the Plascon evidence. That was at times, it's one of the deck chairs that just went, my lord. The Plascon evidence rule, yes, that rule does apply, but the court also is entitled to adopt a robust approach. A line of cases, Sofiantini versus Mold, and especially in circumstances such as the present, where we sit, the court has to deal on an urgent basis. It needs to adopt that common sense approach advocated in those line of cases that go back many, many decades, and tells the court how it should deal with if there are disputes, or fact which I contend there are not. Then the question of the defective notice of motion, it came as a bit of a surprise to me. What the applicant, how the notice of motion is structured, is a declarator declaring the right of the applicant to have the body repatriated, coupled with an interdict that the sheriff would be entitled to cause the transport of the body, and that declaratory relief is squarely grounded on the clear right that the applicant says exists. So the contention that the notice of motion is somewhat flawed, somehow flawed, I submit can't hold any water. When the question or the issues with the counter application, the impossibility and the hardship, those are defences clearly. You don't raise a counter application, you don't bring a counter application to put that before a court. You simply argue, you put the facts and you argue on the facts. If the agreement can't be implemented, if it's impossible, there's no counterclaim that you need to bring. It's when you deal with misrepresentation and the right to resile from the contract, that clearly is on a different plane. There you would need a counter application. I must correct myself, not even. There is authority to the effect that you can raise that as a defense as well, the right to cancel. So it all turns on the merits. In other words, if are there prospects of success, we say there are no, because the facts are missing, and in any event, there is no satisfactory explanation. The last issue, the question of striking out that the respondents seek insofar as the allegations in the counter, in the reply are concerned. I'm not going to read through those, my lord and my lady. If you read through the allegations that the applicant seek to strike, they are clearly not hearsay. For example, where the Attorney General says, based on the evidence, that's one example that comes to mind. Based on the evidence, it is clear that a certain conclusion must follow. They want that struck, they said it's hearsay. That's clearly not hearsay by any stretch of the imagination. That leaves me with costs. My lords, my ladies, the court indicated that an equitable approach, costs always has that component, maybe not to make an order of costs, as to costs. We will obviously not object if you exercise your discretion in that manner, but what we say is ordinarily we would be entitled to costs, and we would also be entitled to the costs of the urgent application. That was because the applicant found out on the 23rd that the funeral will take place on the 25th. It had no choice but to rush to court to interdict the proceedings, and we say that if there's a cost order, the applicant should also be granted the cost of that proceeding or that process.
About the conduct of the applicant in approaching this court on an expected basis, as in effect, the matter that was already proposed.
Yes.
Is that something that we need to look at?
My lord, what happened there?
Yes.
What happened there is that there was some debate between the parties as to the interpretation of the court order, and the applicant invited the respondent to state its interpretation of the order, which was
made by agreement. We should keep that in mind.
yes, yes. What the applicant said is that our understanding, taking into consideration the context of that order, is that the body will stay with the undertaker and you can't remove it. And the reason why that debate ensued was because the applicant obtained information that there may be an attempt to move the body. And when the respondent then said, no, we're not in agreement, that's not how the order should be interpreted, the applicant approached the court on the basis that the order was granted in the common or on the common understanding that the body will not be moved, because it will not make sense if these proceedings would proceed and in the interim the respondents can simply move the body, bury it to whatever the proceedings set out to prevent. Now the respondents complain and say no, but the attorney must let the court. That is simply presumptuous, and if they proceed with complaint, they're obviously welcome to do so. That complaint will be dealt with, no doubt, accordingly. So, my Lord, you may consider the ex parte application. If I'm correct, we don't see costs as far as that is concerned. My learned junior can check. I don't think, yes. So those costs shouldn't play a role, and you can take it into account, certainly. My pleasure.
Thank you very much. The sample submissions made by our council. We hope it will make our task, this typical task, a bit easier to deal with. We are also alive. There is an urgent matter that is the judgment should be delivered quickly. The undertaking that this court can make is that they will ensure that judgment is delivered not later than Friday. It may be tomorrow, but not later than Friday.
May I please?
And those ladies, court agents.